Good morning. Thank you, Laura. My name is Dan Fitzgerald. I'm a partner in our Greenwich office. My topic today is 10 things you need to know about establishing a domicile in a tax-friendly jurisdiction. And it might be the most important topic today because if we see the repeal of the federal estate tax, clients are still going to have to be worried about state estate taxes. It also might be the most important topic today because we're going to be moving your clients out of this. This is literally a picture of my house in February of 2015 and into this. So while President-elect Trump talked a lot about an immigration problem in the U.S. on the campaign trail, the Northeastern states such as Connecticut and New York are facing a very different migration problem, and that is an out-migration problem. These states, wealthy residents are leaving these states in record numbers to get to warmer weather and lower taxes. For example, Connecticut is averaging a net loss between 10 to 15,000 people each year. So in 2008, Connecticut Department of Revenue Services did a survey of estate planning lawyers, accountants, some of you in the room may have responded to this survey, to find out if people were actually leaving Connecticut due to the Connecticut estate tax. And back then, 52% of the responders said yes, people are leaving Connecticut because of the estate tax. So since 2008, Connecticut's been all over the board with its estate tax. We went up to 3.5 million, we went back down to 2 million. We raised or lowered the top tax rate down to 12%, and we've raised income taxes. We've uncapped the probate court fee, and then we've recapped the probate court fee at a $40,000 figure. So while I have 200 of you in the room, I thought by a show of hands, I'd ask you how many people have been working with clients or think that people are actually leaving the state of Connecticut because of the tax situation. So you can see it's way more than 50% of the room now thinks that, right? And I think we've seen that trend in our practice. So the snow and lower taxes are driving a lot of people to migrate south. My little role today is to give you guys the knowledge to have your clients change their domicile in a manner so they don't have to come back here to face either an estate tax audit or an income tax audit in Connecticut or New York. We've never really advocated uprooting a family just because of taxes, but like many of you, our clients already have ties in multiple states, whether it's a vacation home or business ties. So it's really about tweaking their current lifestyle to make sure we're not going to pay any unnecessary estate or income taxes. So the first thing I wanted you to know is what this means for a cost in real dollars to a client. And this slide just simply shows the income tax due in Connecticut or New York for a married couple filing jointly with no dependents in these states, and comparing it obviously to Florida, which has no income tax. So I'll point out that Connecticut recently added a higher 6.88% income tax bracket for income over $250,000 and a 6.99% bracket or 7% for income over $500,000. And keep in mind, Connecticut taxes you on your gross income with no deductions. In comparison, New York has a top rate of 8.82%, but that's for income over $2 million. But New York does allow some deductions. So I know the accountants in the room will point out that my New York column and New York column are not really comparing apples to apples, but I wanted to give you some sense of the amount of dollars a client can save every year by being in a non-tax jurisdiction. And I am certain that every client would be better off investing these amounts with all of you than investing them with the state governments. The next slide shows the cost of dying in Connecticut and New York as a domiciliary of that state. I'm sure you're all probably aware that Connecticut and New York keep their own separate estate tax systems. Connecticut decoupled way back in 2005 and has its own estate tax exemption and progressive rate structure ever since. As a reminder, the current exemption is $2 million. It's set to be permanently $2 million, but as we know, they've changed it 3 times over the last decade, normally as part of a budget deal. Right now, the rate structure starts at 7.2%, just over $2 million, and goes all the way up to 12% for assets over $10.1 million. 2 years ago, the legislature gave really wealthy people a tax break. They have capped the Connecticut estate tax at $20 million for those estates over $175 million. Connecticut is the only state that still maintains its own gift tax that taxes wealth transfers during life. The Connecticut gift tax exemption is also $2 million, and it's unified with the Connecticut estate tax exemption, so the amount of gifts you use during your life will reduce the amount of exemption available at death. So the numbers are big. A $20 million decedent in Connecticut can save almost $2 million by moving their residence and domicile to Florida. Similarly, New York recently changed its estate tax regime. If you die today, you have a $4,187,500 estate tax exemption. If you die April 2nd of next year, your exemption goes up to $5,250,000. That's going to keep going up each year until 2019, where it's going to match the federal and stay with the federal if we have a federal, as the federal adjusts for inflation. The New York rate structure is 8% all the way up to 16%. However, New York has this really tricky thing that if the gross estate exceeds 5% of the exemption amount, you essentially lose your exemption and you're paying tax from $1. So for larger estates, it's easier to just think about New York that you have no New York estate tax exemption. Lastly, on New York recently changed how they tax non-residence estates that own New York property. The current rule is that if the value of that New York property is below the exemption, there is no tax in New York. It used to be based on a fraction of the New York property compared to the federal gross estate. So the third thing I want you to know when advising that baby boomer who is heading south is the difference between domicile and residence. And residence and domicile are going to be determinative for income tax purposes, and domicile alone will be the determinative factor for estate tax purposes. So income tax residence varies on state law, and it's a very common misnomer that the only thing that matters is 6 months and a day or 183 days. That is simply not true. It's actually a two-part test. So you're going to be subject to income tax in Connecticut or New York if you are either domiciled in these states, or if you are domiciled in another state but become a statutory resident by doing two things: spending 183 days here and keeping a permanent place of abode. So that's that typical snowbird scenario where they're spending half their year in Florida and half their time here, and they keep a residence in both places. And this is where they run into trouble. So they either even haven't done enough to change their domicile, or they inadvertently spend over 183 days in one of these Northeastern states. So those worried about being statutory residents need to keep a day calendar. I'm sure you've all heard of that before. And what most people don't understand or get is that you have to count any part of a day in that state as a day in that state. So the New York guidelines go as far as to say that any time a taxpayer steps his foot into the state of New York, that is a day in New York. So anytime a client goes to a Broadway show or dinner in New York, that's a day in New York. New York does have two very limited exceptions. One is if you fly out of LaGuardia and you travel through New York to get to LaGuardia and travel out of state, there's a transportation exception, so that doesn't count as a day. And also, if you are at dinner in New York City and you have a heart attack and you are in the hospital and you can't leave the hospital, New York is kind enough not to count those days you're hospitalized as days in New York. Connecticut has the same rules for day counting. It does not have the medical exception, so Connecticut's not even that generous. What is a permanent place of abode? This is really any home or structure that's suitable for year-round use, even if it's not used year-round, even if it's leased to another party or you're leasing it. The New York case law says it has to be more than a mere camp or cottage. And here I really just want to illustrate the dangers here, and it's an amazing case. It's a 2011 case. It's where New York was successful in having a Connecticut domiciliary taxed in New York as a statutory resident. Let me give you the facts. The husband and wife were living in New Canaan. The husband, there's no question they were domiciled in Connecticut. The husband was commuting to Manhattan every day, working at a big Manhattan bank. So every day he was going in, that was a day in New York. They had significant investment income, and they also had a small vacation house in the Hamptons. So even though the couple only spent 19 days at their vacation house in 2002, 16 days at their vacation house in 2003, and 18 days in 2004, and the wife's parents used the house way more than they did, the ownership of the house in the Hamptons, and coupled with the husband commuting to Manhattan every day, made them both a Connecticut domiciliary and a New York State statutory resident. So they had to pay on their investment income state income tax to Connecticut and to New York, and there's no credits available, so it's double taxation. Domicile is really this wishy-washy standard where the courts and tax authorities try to determine a client's intention and where the center of the client's domestic and social civil life are. There is no bright line test for domicile. Domicile requires not only a physical presence, but this intention component where the taxpayer makes an active decision to make a place a permanent home. Courts and tax authorities will look at a variety of factors to determine domicile. They'll look at where you vote, where you have your bills mailed to, where you go to church or synagogue, where you have your driver's license, where your cars are registered, where you keep your more valuable possessions. If you keep the Ferrari in your Greenwich home, that's going to be a sign that you're domiciled in Connecticut. Where you have your bank accounts, where you donate to charity, where you go to doctors. All of these factors are things that are factors that show a court where you are domiciled. They do take into account how many days you spend in a place, but it is not a determinative factor at all for domicile. So no person can have more than one domicile, and you can only gain a new domicile by abandoning an old domicile. And it's our job as lawyers and your job as advisors to help people document that change in domicile so we can build a file to show state tax auditors something on paper showing that intention to change domicile. Keep in mind, if it's an estate tax audit, your client's not going to be around to testify as to their intention. As Laura said, they're already dead. And both Connecticut and New York are putting resources into tracking down these estates and income taxpayers for good reason, right? It's an easy way for them to get money, and the people affected no longer vote in state. So another New York tax case I wanted to highlight is really an example of an incomplete domicile change. Although it's 2007, it just recently was published. And Dr. Campanelli was a longtime Manhattan resident, and he filed his 2007 New York income tax return as a non-resident. He had maintained his apartment in Manhattan. He continued to have his mail go to Manhattan. He maintained his personal belongings in Manhattan. But in 2007, he only spent 169 days in New York, and the rest of the time at his house in Florida. New York held that he had not done enough to change his domicile to Florida. So he was still subject to income tax, and his tax bill was big. He had to pay over $500,000 of interest and back taxes and penalties. So Dr. Campanelli, what could he have done better? He probably should have spent more time at the Florida house, obviously. He could have had his bills sent to Florida. He could have filed an affidavit of domicile and a homestead declaration in Florida. So these are all steps. We want to get all the facts pointing in the right direction and not have a mixed bag of facts when these audits occur. All right, so our firm has established a 3-page checklist that you can always ask your attorneys to provide for you that really lays out the steps to establish a domicile in a no tax jurisdiction. These include filing an affidavit of domicile in a state that allows that procedure or has that procedure available, obtaining a new driver's license, transferring your voter registration to that state. Maybe it'll be a swing state where your vote will count more. Use your new address when filing your income tax returns. Apply for the state's homestead exemption. For example, in Florida, there's a generous homestead protection for residents that caps the amount your property taxes can increase each year and provides certain protection from creditors. You should also hire a Cummings Lockwood lawyer to draft you new wills and revocable trusts in that jurisdiction, reciting that you are now a domiciliary of that state. And to the extent possible, you should join religious clubs and organizations in that jurisdiction. In your old state, you want to do the opposite. You want to cut ties to the extent possible. You want to minimize your time in state. You want to surrender your driver's license, license plates, get removed from voter lists. If the state will accept it, you should send your domicile declaration from your new state to your old state. In your last year of income tax returns, you should mark it as final. And if you're required to file in that state in the future, you should mark it as a non-resident. And you should change any club memberships up north to a non-resident status. Some of the clubs have caught on to this and created non-resident status. I'm not sure it gives you any break on your annual dues, but at least it's something. So with that, I've given you 10 things to know, but really I want you to walk away with one thing, in that it's not just about day counting. It's really more about domicile and building a big file of all the documents we can to make sure that all of the facts point in the right direction if and when your clients are audited by the tax authorities.